Okay, so administrative hearings. So the mess, right? How did we get to where we are today? So I wanted to give you a little bit of background so you understand how we got where we are today and why we've made the changes that we have. So this all starts with Senate Bill 2176, which was effective in August of 2017. And this was the legislature's attempt to revise the implied consent advisory after the Birchfield decision. So we all know with Birchfield, the United States Supreme Court said you can condition a breath test, right, a refusal on a breath test because it's a valid search incident to arrest, but they said you can't do that with blood. You can't tell someone, better take my blood test or I'm going to cite you for refusal. We had to get a warrant. So as a result of that, we had Senate Bill 2176, which revised that implied consent language. And at the time, the Birchfield decision did not address urine. It is a case that only talked about, those three cases that they took up, only talked about blood and breath. So there was no mention of urine. So at the time, the legislature was trying to say, well, we're going to try to preempt this, and we're going to put in our law that urine is like breath. Okay, so obviously we wanted that because we didn't want to have to be forced to get the warrant. We wanted to be able to have that streamlined process. So the statute, the implied consent advisory, was written so that urine would be equated with breath. That lasted a very, very short amount of time. And shortly after that, we had the decision of State v. Helm, a case out of Cass County, where they had a urine test and that person refused, and the district judge tossed it and said, I think urine is like blood. I'm not going to let you use your test. And the state's attorneys in Cass County appealed to the North Dakota Supreme Court, and the North Dakota Supreme Court reviewed this and decided, we agree with the district judge, urine is more like blood than it is like breath, because it is a privacy concern, because it's difficult to get a sample without invading someone's privacy, the embarrassment factor, and because when you retain a urine sample, it can potentially be retained for other evidentiary value. So they said because of that, they thought urine was more like blood, and therefore you can't condition a urine test on a threat of a criminal refusal. You have to get their permission or you have to get a warrant. So prosecutors scrambled, right? This case came out, prosecutors got together, what are we gonna do? How are we gonna fix this? We have an advisory that says breath and urine, and now we're being told that we can't do that because urine is like blood, and you have to get a urine, you can't threaten a criminal refusal. So we scrambled, right, and we're getting out to law enforcement throughout the state, don't do this. Take out the or urine when you do the advisory because of Helm. Or urine is not constitutional, that's improper, take that language out, okay? So pretty, it's been almost 2 years. I mean, it was probably very close to this time, August, September, that we were saying, already change the advisory that's in the statute. So that brings us to the Schoen case, and this is a 2018 North Dakota Supreme Court case regarding a Department of Transportation license suspension. And in that particular case, when the officer read the advisory, he did not read the part about the criminal refusal because he was asking for a blood test. And so he did that based on what was going on with Birchfield at the time. What needs to be clear about Schoen is that Schoen was before the 2017 amendment. Okay, so Schoen was dealing with the advisory that existed in 2015. Okay, so at that time the officer said, I'm not going to read the portion about the criminal refusal, and the Supreme Court, the North Dakota Supreme Court, analyzed this and said, no, you did not comply with the statute because the statute refers to chemical test. If you refuse my chemical test, you can be charged with a refusal. And the state had to concede that that was still an appropriate advisory when talking about breath, because that was appropriate with breath. And so the Supreme Court said, Birchfield didn't say the statute was unconstitutional. Birchfield just said, right, this process is not proper. And so the Supreme Court, the North Dakota Supreme Court, acknowledged in the Schoen decision that basically law enforcement were stuck, that there was no way for you to get a blood or urine test without first getting a warrant. And they acknowledged that. And they said, yep, the advisory doesn't work. The advisory would be improper when asking for a blood test, but that's what the statute required. You didn't comply with the statute because the statute has the exclusionary rule. Yeah, law enforcement were kind of stuck. You had to get a warrant. So when this decision came out again, panic. Prosecutors got together and said, what is going on here? What are we going to do? And we came to the conclusion that this was very situational, that this had to do with the 2015, right, the pre-2017 amendments. Since 2017, we had broken it out for blood, for breath, for urine, and we really didn't have this issue or this problem anymore. So we decided this was situational. We didn't really do anything with it, okay? Unfortunately, this case foreshadowed what was going to happen a year later, okay? So this was the first case where the North Dakota Supreme Court said, you have to do what the statute says, okay? Strict constructionalists are what we have on the bench right now. So that leads us to the DeForest case, another administrative hearing case. And in this particular case, the officer read the implied consent advisory, omitting the reference to the criminal penalties, and requested a blood test. Okay, so did the right thing and said, just read you can lose your license if you don't take this test. Okay, will you take my blood test? So the officer did what we advised, what the statute requires. And the defense attorney argued and said, no, you have to read the entire statute. You have to read the entire, 29 or 3920-13A. You have to read the whole thing in its entirety, which means talk about the breath, the urine, and the blood. You had to read all of it, okay? So we are back at the Supreme Court arguing this. We're like, that's dumb. There's a part in the statute that says, do not advise the criminal refusals if asking for a blood test, okay? So the Supreme Court agreed with us, and they broke down, this is a great little English lesson, this case, because they break down what the word if means and how to basically conjugate a sentence, and that, because that word if was there, that means it's conditioned on this other thing happening. So basically said it's illogical that we would expect law enforcement to advise someone about breath and urine when you're requesting a blood test. Okay, so they said, officer did it right. The if is only, it makes it clear that you're only supposed to do that if you're asking for a blood test. And it's just that there's no logical reason to read the advisory for breath and urine. It would just confuse people, okay? So this would seem to, this is a good decision for us, seems logical. Right? When you're talking about blood, talk about blood. When you're talking about breath, talk about breath. Okay? So we thought this is good. Then we have the LeClaire v. Sorrell case. This is another case where an officer read the advisory, but instead of saying refusal is a crime punishable in the same manner as DUI, the officer said refusal is a crime and you can be arrested or something. Took out the word punishable. So we had a challenge. The defense attorney said, hey, didn't read the statute. The statute requires the word punishable. They didn't comply with the statute. The test should be suppressed. Again, the North Dakota Supreme Court reviewed this and said the word punishable was not a substantive word. Wasn't a substantive requirement of the statute in order to properly advise that driver of what their options were. And again, they talk about the word crime, and that crime in and of itself denotes a punishment. And so they said they thought the word was redundant and not necessary, and that omission of the word did not substantially change the meaning of the advisory. And they reiterated that they have never required a word for word recitation of the implied consent advisory. So again, we're thinking this is good, this is logical. It's just about making sure that information is relayed. It's not about the magic words, okay? City of Grand Forks v. Barrett. This came out of my office, actually, and this was a case where the officer arrested, I have to remember now what the sequence was, he read implied consent, asked the person to take the breath test, and then arrested them. And this all occurred like simultaneously. Implied consent, will you take my test? Okay, and by the way, you're under arrest for DUI. Okay? All occurred together. So the district court suppressed our test and said under the O'Connor decision that it's very clear you have to arrest first, then read implied consent, then do the test. And we argued that in O'Connor, that was just like a throwaway dicta kind of statement in the O'Connor case, that case was about something else entirely, and that it was being misconstrued. The Supreme Court said, nope, we think that the statute is pretty clear that you have to arrest first, then read implied consent advisory, then test. So they made it very clear if things did not occur in that sequence, your test would not be admissible. So that brings us to 2019. And we have the State v. Dowdy case. So that was earlier this year. And in that particular case, the officer read the advisory, but added the words, and includes being arrested. So he said refusal is a crime, punishable in the same manner as DUI, and includes being arrested. Okay, so those words are not in the advisory. In the statute, the defense attorney appeals and says, hey, you provided incorrect, you provided false or additional information, I shouldn't say false, but additional information. You didn't comply with the statute. The Supreme Court looked at this as well and said, as long as the additional language being added is accurate, we see no harm in it. So they again analyzed what was going on here. This guy already was arrested. You know, this really doesn't mean anything that the officer said this. It is true. It's an additional charge that you could be arrested for. So they said as long as that additional language, if accurate, does not alter the sufficiency of the advisory, they didn't see a problem with it. So this goes back to that idea, right, that it's not a word-for-word recitation. It's about making sure the information is being relayed in the correct manner, that you're relaying the correct information to the driver so they can make an informed decision about whether to take the chemical test that you are requesting. So looking at this, the reason I go through this chronology is because when you look at this, logically speaking, right, the Supreme Court has said, you know, why do we talk about breath and urine when we're asking for a blood test? That's just confusing. Why are we worried about words that aren't important as long as the relevant information is being relayed? We don't require a word-for-word recitation, so we're thinking all of this should be working in our favor, okay? Until we get to State v. Vegan. And this is the case that set everybody on their heels. We still don't get it. It's completely illogical, but we are stuck with it, okay? Well, until August 1, and now we have a new law. But, so State v. Vegan came out, and this case finally dealt with the instructions that we had given law enforcement 2 years ago, right? When we said take out those words or urine when you're asking for a breath test because it's just going to confuse things. It doesn't work. It's not constitutional. So take out those words or urine. So in this particular case, the officer did that, read the advisory as written in the statute, omitting the words or urine, which is pretty much what all of you have been doing for the last 2 years, correct? Right? That's what we told you to do. So the officer, read the advisory, omitted those words or urine. The hearing officer said, the court said, I think it's fine. The district court said it was fine. There was a conditional plea, so the person pled guilty with the right to appeal this issue to the North Dakota Supreme Court. So it goes to the North Dakota Supreme Court. And the North Dakota Supreme Court looks at this and says the complete opposite of what they've been saying for the last year and a half, right? They said the words or urine are substantial, that they are critical, and that omission of those words or urine means you did not comply with the statute, and because there is an exclusionary rule, the test must be suppressed. Okay? So they said these words were important. Okay? They didn't discuss. We didn't get an English lesson on the word or, which I think would have been a good time for that, because we're not asking for, it wasn't a urine test, right? It was a breath test. So why do we care about the words or urine when you're not asking for a urine test? We have the fact that they said previously, right? Why confuse things when you're not, talking about tests that you're not asking for? But they said it was required. They said that Helm didn't specifically find the statute unconstitutional. That was the other piece that is still a little bit difficult to understand. They said, Helm, we simply said that you can't condition a urine test on a threat of a criminal refusal. But they said that we never said the statute itself was unconstitutional. So that's the piece that prosecutors are all like, but what else are you saying? If you're saying you can't do that, then by definition that statute doesn't work anymore. We were trying to modify the statute so that it complied with what the court said you could or could not do. They talk about the fact that the defendant didn't actually challenge it on constitutional grounds. He challenged it on statutory grounds. And so they said because it was never a constitutional challenge, that they weren't going to analyze whether it was constitutional. They were going to analyze it strictly on the fact that the statute requires the words or urine. Those words are substantial, and omission of them means your test must be suppressed. So obviously this was the third time in the last 18 months that we've had to have emergency meetings about what are we going to do, how are we going to fix this, what's the problem, law enforcement was already confused enough. We were like, gosh, if we send out another recommendation and another advisory, people are going to be so confused by this and what's going to happen. So what we came up with was follow the advisory on the report and notice form. And the report and notice forms were issued back in 2017 when the law was changed, and the report and notice still had that language or urine on them. So we told everybody, ditch your cards, right? Ditch whatever you're using, just read the advisory off the report and notice form. I heard that there still have been some issues with that there are still some jurisdictions where the judges are still saying that's not accurate either, and doesn't comply with the statute, and we've still had tests suppressed. And so we were all like, whatever, your guess is as good as ours, do the best you can, we're just waiting for August 1st to roll around, okay? So this is one I've said to people, as a prosecutor, I feel like we really missed the boat somehow, but we all thought the same thing. I mean, this was, a lot of us got together and came to the same conclusion. We just did not expect that we would have a Supreme Court that they're strict constructionalists. I mean, they're very literal in how they're reading our statutes. So let that be advice to you moving forward, that's the makeup of this particular North Dakota Supreme Court. So the good news is that when vegan came out, we were in a legislative session. So we were able to take this information and use it to try to fix the problem. And so Aaron Burse was working very hard, worked with a lot of legislators who were involved in this and interested in fixing DUI law. And he worked with them, and we were able to come up with what we think is a good fix. As you know, we cannot ever anticipate all of the arguments that the defense bar will come up with. They're a very, they're good at coming up with different arguments, different ways of looking at things, different arguments. Creative is the word I'm looking for. So Erin works on this. We have a lot of meetings about what will work, what won't work, where can we make the changes, what should we do, how will this impact things. What I'm learning is that I would never be a good lobbyist because the pace that these things move at does not sit well with me, and you have to make very quick decisions to get things done, right? You don't have time to sit and think about it. They're having a meeting tomorrow, and you have to have something presented. So you have to work quick when you're doing this, and so we do the best we can to anticipate what we need and what the problems are going to be, but as you know, there are always some kind of unintended consequences to legislative changes. The other interesting thing about this was that kind of at the tail end of this, we had pretty much a bill that we thought was going to pass, and right at the tail end, the defense bar got organized, and they started to wage their own war against this bill, and they always go for the jugular, right? It's unconstitutional. You're depriving people of their constitutional rights, and then that gets legislators really freaked out. And we have to go back and say, no, that's not what we're doing. This protects constitutional rights. You can trust us on this. That's not what we're doing. So it's always an interesting kind of battle back and forth. But what we have, and the main reason we're here today, is that House Bill 1534 did pass, which addresses the changes that we're going to talk about today that have gone into effect. As many of you know, there were three sections to this bill. The first two got in an emergency clause, but the third one didn't for some reason. We don't really know why. We caught it before the end of the legislative session, but we were afraid if we opened this up again and brought it back up, that it would allow the defense bar to come back in and make an issue. So in the end, we're like, you know what, we're just going to let this go. We're going to do the best we can and just try to make it to August 1st. So that's what happened there. So the first two that had the emergency clause that went into effect right away would have been great, except that the exclusionary rule still existed in Section 3, and that's what caused all of our problems. So in the end, the emergency clause was essentially useless. It did nothing for us because we still had that exclusionary clause that existed until August 1. So even though on the criminal side, the law had been eased up a lot, we couldn't put it into application because that exclusionary rule still existed in that third section.
So, Aaron Burse was able to get House Bill 1534 passed, and we had a game plan for how we were going to proceed, and advice that we were going to give to law enforcement regarding how to handle the new law and the new implied consent advisory. Unfortunately, the Supreme Court issued a new decision in City of Bismarck v. Vatz, 2019 ND 224. Obviously, this is a case that came out of the City of Bismarck. The prosecutor contacted Aaron and myself and the Attorney General's office immediately when this decision was issued, because he did recognize it was going to have impact on the advisory being recommended for law enforcement. And in the Vatz case, the officer was reading the implied consent advisory off the back of the report notice form, as we had advised to do. Unfortunately, that advisory did not include the words directed by a law enforcement officer. So this got appealed again on the same argument by the defense bar that law enforcement was not complying with the statute in reading all of the required language. The Supreme Court reviewed this and agreed with the defense attorney. The Supreme Court's decision was that those terms directed by a law enforcement officer were necessary in order to make it clear that we were asking individuals or subjects, the driver, to take the test that the officer was asking rather than an independent test. This decision refers to 39-2001 subsection 2, which talks about the fact that the law enforcement officer is the one who gets to choose what test is being requested. 39-2001 subsection 4 talks about a driver's right to an independent test. The Supreme Court felt that the language in the implied consent advisory directed by a law enforcement officer made it clear that the test that they had to take was the one that the officer could request. This, of course, had to assume that the regular driver would understand that they had a right to an independent test. It ignored the fact that it was the officer saying, will you take my test, or will you take this test? Obviously, it's the one that the law enforcement officer is requesting. But the Supreme Court required or stated that that language was substantial and needed to be included in the implied consent advisory. So obviously this changed our game plan moving forward, because the opinion was that language wasn't necessary, that it was superfluous, and that we could take it out of the advisory. So obviously that was a mistake, and we had to, again, scramble immediately to fix that. This meant we had to issue new report and notice forms. We had to get out a new memo to all of law enforcement to advise them of this other change. And it was going to impact the advice that we were deciding to give to law enforcement regarding the new implied consent advisory. The post House Bill 1534, or the law that went into effect as of August 1, 2019, still contains that language. The advisory still contains that language directed by a law enforcement officer. So we knew that we needed to make sure that was included moving forward. So that will impact will impact the advisory that we're giving, and will result in new report and notice forms being issued.
So we'll break that down. So House Bill 1534, again, went into effect August 1, for all intents and purposes, went into effect on August 1. So the first thing that this did was amend 39-2001 subsection 1 to put saliva back in. And some of you may recall that saliva used to be in the statute. Some of the people who have been around as long as I have will recall that saliva was there. I think maybe 6 or 8 years ago, Aaron and I said, "Oh, take it out. We don't use saliva. Why do we even have it in there? That's stupid." And we told them to take it out. And then, of course, marijuana became really prevalent, and then we started to have, roadside oral swab testing, and we're like, okay, sorry, that was stupid of us. We didn't anticipate that. And so we fought to have that put back in, just in anticipation of the drugs and future testing that we might have. We do not have it yet. Okay, so North Dakota does not have any method at this time for testing saliva, but we hope to in the next couple years. And I'm sure all of you have heard of other states that are testing, roadside devices to test for drugs. So we're looking at trying to do something like that in the next couple years. So we got a little bit ahead of ourselves, but we're hoping now if we want to do a pilot project or something, we're in better shape to get it done. So we put saliva back in. All right. The bill also amends 39-2001 subsection 2, and it says very specifically, this is the part that was changed, the tests, that should be test singular, the test or tests must be administered at the direction of a law enforcement officer only after placing the individual under arrest for violation of section 390801 or equivalent offense. For the purpose of this chapter, the taking into custody of a child under section 27-2013 or an individual under 21 years of age satisfies the requirement of an arrest. The law enforcement officer shall determine which of the tests to be used. So this language still requires that someone has to be under arrest before you can test them. Okay? So you still have to place them under arrest before you can ask them, before you can have them, submit to a chemical breath, urine, or blood test, okay? We know that taking a child into custody or someone under the age of 21 meets that arrest requirement, okay? So the arrest must occur before the test can be administered, right? So the good news here is, if you recall the Barrett case, City of Grand Forks v. Barrett, and that's the case where the Supreme Court said, no, you have to arrest, read the advisory, then do the test. This fixes that, okay? So we have that this just talks about after placing the individual under arrest. It doesn't say anything about implied consent, okay? So that brings us to 3920.01.3a, which is the new advisory. The law enforcement officer shall inform the individual. It no longer says the individual charged. Okay, we took out the word charged. So it's not about that the person's been arrested. We're just talking about the individual, okay? So the law enforcement officer shall inform the individual. North Dakota law requires the individual to take a chemical test to determine whether the individual is under the influence of alcohol or drugs, and refusal of the individual to submit to a test directed by the law enforcement officer may result in a revocation of the individual's driving privileges for a minimum of 180 days and up to 3 years. So it no longer says the individual charged. So it should not matter, okay? The goal of this was that it should not matter if you read implied consent before you place someone under arrest. Okay, that sequence should no longer be significant. So if you read implied consent and then arrested them, that should be fine, okay? As long as they're arrested before you administer the test. So I think you could technically, in theory, say read the implied consent, say, will you take my test? They say yes, and then you could say, okay, by the way, you're under arrest, and that is still going to be in compliance with the statute. That said, the old way of doing it, arrest, implied consent, test, it works. So if that's what you've been doing, you can continue to do it. We're just letting you know that that kind of goof up, if you think, oh crud, I did that wrong, shouldn't matter anymore. Okay? So you have a little bit of flexibility depending on the type of defendant you're dealing with and how complicated they're being and how you want to try to deal with them and approach them. This gives you a little bit of flexibility about what order you do those things, okay? So it fixes that Barrett problem. So obviously the other nice thing about this is that it really does streamline that implied consent advisory. This goes back to more like it was, 2013, okay? This is going back a little bit, but this advisory is back the way it was supposed to be. This is what implied consent is, right? Implied consent is a warning about your driver's license. That's all it was ever intended to be. And when the legislature pulled in all the criminal stuff, that's when they caused the problems, because that is not what implied consent was intended for. Implied consent was intended to advise them of the fact that they could lose their license. Okay, that's all it was ever intended for. So this implied consent advisory does that. It just says, hey, whatever test you don't have to talk about blood, breath, or urine. Okay, this applies equally across the board, so no matter what test you're asking for, you read the same advisory. And you advise them that if you don't take my test, you could lose your license for a minimum of 180 days and up to 3 years. That's it, okay? That is implied consent. So this goes back to, we have here exact language is strongly recommended. This bullet here, exact language is strongly recommended. It should not be required. Okay, the Supreme Court has said for years, and they said as recently as 2018 and 2019, they have said that we have never required a word-for-word recitation of the implied consent advisory. Okay, they've never have. But what they have required is that you substantially comply. So that was one of the discussions we had. It was like, what kind of language could we put in here that just makes it clear that it's about substantial compliance? But we were afraid if we started to do that, then they would start analyzing what is substantial compliance, right? And that would cause a whole other slew of problems. So we streamlined the advisory. It's the same now for blood, breath, urine, and it's what implied consent was intended for. This is just about license revocation, Okay? This is directly out of the statute. Questions about that? And we'll talk about implied consent a little bit more.
Now, you talked about the order of the recitation of the implied consent advisory as it applies to arrest. Is this reading of the implied consent separate, a different reading from when you request a preliminary breath test? Okay.
It is. The advisory for the preliminary breath test did not change. Okay, so that advisory is still the same.
And must be read separately.
Correct.
From this reading.
Yep. And that was the problem in the O'Connor case that I didn't talk about today, but that Barrett referred to. In O'Connor, the officer read the advisory for the PBT and then said, hey, you remember that advisory I read you earlier? Keeping that in mind, do you want to take a breath test now, or whatever test it was? And the Supreme Court said, you have to read the advisory. It's a separate advisory for the chemical test, okay? So that's been made clear. So the PBT advisory did not change, and that is still a separate advisory from the chemical test, okay? The evidentiary chemical test advisory. Good question. So 3920.01(3)(b), okay? This is the exclusionary rule. This is the part of the statute that said if you do not inform the driver of the implied consent advisory as required in 3A, your test cannot be used in a criminal or administrative proceeding, okay? That was the problem, and that is what the Supreme Court was hitting on time and time again, was that 3B, okay? They even said, in most of those decisions, they said the legislature needs to fix this. They repeatedly were telling the legislature, fix it, okay? So they were certainly sending a message to the legislature that this was stupid, okay? So this was where the fight really came in, because the legislature has been convinced that it's not fair to penalize someone for refusal if they don't know what's going to happen to them. They feel very strongly that people should be advised of what is going to happen to them if they refuse a chemical test. So we were able to convince them then that then don't punish them because they consented. The punishment shouldn't be you can't use a good test, right? If someone has consented to a test, it does not make sense to say you can't use that good test because they weren't properly advised, okay? It makes more sense if the advisory is about, hey, this is what happens if you refuse, then what we should be doing is if they're not notified of what happens when they refuse, then we shouldn't get to use that refusal against them. Does that make sense? So, I mean, that's been the problem with that exclusionary rule, is that you get a test. People can consent to take a test. And we are being told we can't use a perfectly good, legally obtained test because you screwed up reading an advisory. Okay, so they created this statutory rule that was taking away perfectly good admissible evidence when the advisory doesn't even say, hey, if you take this and you're 0.16 or greater, you're going to lose your license for 180 days. It doesn't even tell them that, right? It tells them that if you refuse it, you can lose your license, okay? So we were able to convince, or Aaron, I guess, was able to convince the legislature that that should be what the consequence is, that if they're not advised of the consequence of refusing, then the refusal should not be admissible. Excuse me. So the other thing we were able to convince them is that implied consent is about the license. That's it, okay? It's not about the criminal side. Implied consent is about license suspensions and revocations. So the two really good things that came out of this were that it says proof of the refusal is not admissible in any administrative proceeding. So there's no reference here. So if you forget to read the advisory and they take a test, the test is good, okay? Because they consented. Consent is an exception to the warrant requirement. They can consent to taking that test, right? We have no constitutional violation. The test comes in, okay? But if you forget to read the advisory and they don't take the test, that refusal is not going to be admissible in the administrative proceeding. Okay? Only the administrative proceeding, because implied consent should only impact the administrative proceeding, not the criminal side. So we're pretty excited about this. Okay, we're excited that this is only impacting refusal cases now, and it's only going to impact on that administrative side, in theory. Okay, that was the goal anyway. So this is good. So as I said, I'm going to repeat myself. If you forget to read the implied consent advisory and they take the test is still admissible. If you forget to read the implied consent advisory and they refuse, the refusal is not admissible in the administrative proceeding. Okay. So the gist of this is we still want you to read the advisory. Okay? We still want you to. This is how we're going to get those license suspensions. This is how we're going to be able to pursue the administrative side, the advisory, and it says the officer shall, right? So again, it is still a requirement of law enforcement that you are supposed to read this advisory. It's just a little bit less critical now if there's an error or a problem, because it should only impact the administrative side. And we aren't necessarily going to lose the criminal side. Questions about that? I'm getting some head nods. Are people following me? Okay. So there was also a change to 390801 subsection 1. 390801, of course, is the criminal side. It's the criminal statute. And they added a subsection F. So we have, A is under the or A is per se, B is under the influence, C is drugs, D is combination, right? We go through all those. E is the refusal. So it talks about refusing is a crime. And then they added F. And it says subdivision E, subdivision E does not apply to an individual unless the individual has been advised of the consequences of refusing a chemical test consistent with the Constitution of the United States and the Constitution of North Dakota. I love it, okay? This is great stuff. So this is saying the refusal, remember I said the legislature really feels that people should be advised of the consequences of refusal. What's going to happen to them if they refuse? So this, on the criminal side, we've separated administrative from criminal. So on the criminal side, we're saying, hey, if they haven't been advised of the consequences of refusing, then you can't use the refusal, okay? But you'll see here that there's no magic language. It doesn't say you shall inform them of this, okay? It just says that they haven't been advised of the consequences consistent with the Constitution, okay? Well, I mean, it's brilliant, right? So the legislature feels good because they're making us all be constitutional, because, typically we're not, right? So, I mean, that's just dumb. But it means nothing, okay? I mean, the Constitution doesn't require that anyone be notified of the consequences of refusing. There is no constitutional requirement. Those are statutory requirements. Those are not constitutional requirements. All the Constitution says is that you can't condition a refusal, right? Or you can't condition giving a blood or a urine in North Dakota on the threat of a criminal refusal charge. That's all the Constitution says, okay? So there is no magic language, there is no requirement, except that the legislature wants you to, okay? So this was the compromise that Aaron came up with to say, okay, legislature, we hear you, and we will, make sure that law enforcement are still telling people that if they refuse, they're gonna, they could be charged. But there's no magic language, and there's really, I would say arguably, if you forget to do it, we probably could still win, okay? Because there is no constitutional requirement to do it, okay? So that, that's the one that's gonna have the most challenge, I think, and we can talk about that. The other thing that we changed in 390801 is that we added or made it very clear that the language about if you're using your drugs as prescribed, right, that's a defense. They've made it very clear it's an affirmative defense now. So it's no longer on us, on the prosecution and law enforcement, to prove that they were not using it as prescribed. They have to prove that they were, because we've made it an affirmative defense. So we hope that helps us, especially as we see more medical marijuana and those kind of things. That being said, this is where law enforcement need to get used to asking those questions. Now that we have medical marijuana, you need to start asking, do you have a medical marijuana card? You need to ask those questions. Are you taking your medication as prescribed? Who is your doctor? You know, when did you get your prescription filled? I mean, the more information we have about their prescription that they're claiming they have, the better prepared we can be for trial. But now the onus is on them a little bit more to have to prove that up rather than us have to prove the negative, basically, which was fairly impossible to do. So we're hoping that helps. Questions? Now, I'll have, again, we're going to go through the advisory and I'll give you what our advice is, okay, what we're recommending. I just want to make sure you understand how the law has changed. So 390801 subsection 2 was also fixed. You may remember 2 years ago when I was giving this presentation, we found an error. So they had removed the criminal refusal for the PBT. Do you remember that? But then they left the language in there about curing it and stuff. That made no sense. I'm like, you can't cure it. It's no longer a crime. So we finally just got that fixed, okay? So it took out all reference to 392014 because there is no longer a cure requirement or anything with that. It's not a crime anymore, okay? So that was a non-issue. So you don't have to cure. There have been some questions. I know some law enforcement are still confused about that. There's really nothing in the statutes anymore that require you to tell someone of their right to cure. Okay, that's no longer something you need to worry about. If they do cure, I mean, if you ask for a PBT and they refuse, and then you ask them for an evidentiary test and they take it, it will cure it, but you're not obligated to tell them that. Okay, there's nothing there anymore that makes that an issue. So that's one less thing to worry about with curing refusals. Okay. 392014, we were excited about this one as well, and then less excited. So you'll recall that 392014, prior to August 1, only allowed you to request a PBT, an on-site screening, if there had been a motor vehicle crash or there was a moving traffic violation. So that always was kind of a problem if you had an APC or had a non-moving traffic violation that you couldn't ask for a PBT. So we were able to add language that basically says now that you can request a PBT for that moving traffic violation, for that traffic crash, or if you believe the person is DUI. Which I don't know why we just didn't leave it at that. But basically, so that opens it up for pretty much any case that you're doing. If you have any inkling that the person is potentially impaired, this is going to open you up to do that PBT, okay? So you can do this now for any kind of case, APC case, anytime that you have, right, formulated an opinion that the person's body contains alcohol, you have the ability to ask for that PBT, okay? Now, the problem comes in because we did not amend 392004 and 392005. And those are the two statutes that talk about what have to be established in an administrative hearing. And so when it talks about the refusal of the PBT, it says a PBT if the person committed a moving traffic violation or was involved in a traffic crash. We didn't amend those to include the DUI investigation, okay? So this came up though at a meeting I was at last week. I did have a hearing officer tell me that they would still encourage you to still do the PBT. I mean, still request the PBT under 392014. I mean, it's legit. We can use it then in a probable cause challenge on the criminal side. So this shouldn't stop you from still getting that PBT evidence if you think it's going to help you with your investigation. We just may have problems getting it in at an administrative hearing. What this hearing officer said to me, though, is she's like, well, we can still look at 39-2014. She's like, we still have the ability to look at 39-2014, and we can still make a determination whether we are going to consider that PBT evidence. So the message clearly was they might still consider it, okay? So certainly we're just giving you heads up that was an error. Again, one of those things you missed because we're always in a hurry, but still do it, okay? You're allowed to do it under 39-2014. It might still come in on an administrative side, and it absolutely will come in on a probable cause challenge on the criminal side, okay? So hopefully that opens up some investigative tools for you as well when you're doing those APC cases, which is, I know, when that often comes up.
So the new implied consent advisory that we are recommending is basically a verbatim reading of the statute. The law enforcement officer shall inform the individual. North Dakota law requires the individual to take a chemical test to determine whether the individual is under the influence of alcohol or drugs, and refusal of the individual to submit to a test directed by the law enforcement officer may result in a revocation of the individual's driving privileges for a minimum of 180 days and up to 3 years. So because of all of these decisions, we have come to the conclusion that we just cannot mess around with this anymore. We cannot assume that language is going to be considered to be not substantial. The Supreme Court has come down pretty much on the side that everything is substantial and everything has specific meaning. And rather than try to figure out what the Supreme Court is going to do, we think our safest step moving forward is just to read the statute as it's written. We think that will be our best argument, and when we are challenged in court, the best argument for the prosecution is to say we read the statute as it's written, word for word. In fact, it's my understanding that most defense attorneys, when they've been going to the Supreme Court to argue this, have been arguing that exactly that it's very clear what the statute requires. Law enforcement just needs to read the statute. So we're finally giving in to that request, and that's what we're going to recommend you do, is read the statute word for word. Now, the conversation or the concern with this is, of course, that it seems very impersonal, that it's not clear that it's even being directed at that particular driver. When we're talking about the third person, the law enforcement officer shall inform the individual, it seems odd. It's just not the way we normally talk. It's not the way you speak to people. As you will know, in the past, we were always saying, say you, because you're directing it to that individual driver. While again, we think that would be a silly argument, we don't want to put ourselves in that position of having to make those arguments. So we're recommending that you just read it again as it's written in the statute. We are anticipating that the next issue with that will be that they'll make the argument that you didn't identify yourself as law enforcement or make it clear to the driver that they were the individual that you were requesting take the test. This seems like a silly argument, but we've had a bunch of silly arguments with this issue, and we do recognize that is the argument that's going to come forward. Even knowing that, we still think this is the best course of action to take, rather than trying to rephrase or rewrite this advisory in a manner that the Supreme Court will find acceptable. What we are recommending is that after you have read that advisory, that we can address those concerns by saying, I am a law enforcement officer and I am asking you to take this test. Will you take my test? And that makes it clear that you're the law enforcement officer and you're asking that individual who you're talking to take the test. I've heard that some officers are actually doing that before reading the advisory, that they're making it clear, I'm a law enforcement officer, you are the individual, I'm required to read you this advisory, and then they read the advisory. I think that works as well. Or as just indicated at the end, say, I'm the law enforcement officer asking you to take a chemical test. Will you take my test? And I think that should cover any issues that we might have with this. We're hoping that becomes organic, that you just come up with a process that's comfortable for you, and that makes sense to you when you are reading the advisory and asking individuals to take your chemical test. We were reluctant to add any specific language to the advisory or to the statute because we don't want that to be perceived as part of the advisory itself, and because we don't want to add words, we don't want to add requirements, we don't want to make this more complicated than necessary. We want you to do what's comfortable for you, keeping in mind that the court has been very strict in how they're interpreting the advisory and what they're requiring. So despite the fact that the Supreme Court has said repeatedly that you don't need a word-for-word recitation, and they've never required a word-for-word recitation, they are determining that every single portion of this is critical and substantial, and then if any piece is missing, it negates the requirement of the statute in providing that advisory. So rather than continue to fight this battle with the Supreme Court and the defense bar, we think the best course of action is for you to read that advisory as written in the statute. The new report and notice forms are going to be modified to reflect that statutory language.
This advisory can be read for every type of chemical test. So if you're asking for a blood, a breath, or a urine, that advisory should be read. Okay? The advisory can be read before or after arrest. Doesn't matter anymore with the changes to the statute. The test, however, must occur after arrest. So you can't test someone and then decide whether you're going to arrest them. You still have to arrest them before that test is administered. If the person takes the requested test, whether it is a blood, a breath, or a urine, no additional advisory language is going to be needed. Yay, right? So if they consent, we have consent. Consent is an exception to the warrant requirement. We are good to go. Okay, so yeah, reading that advisory about the license, if they consent, we're good. If the person takes the test will be admissible in both the administrative and the criminal proceedings. If the person refuses the test, the refusal will be admissible in the administrative proceeding. If you've read the advisory and they refuse, the refusal will be admissible in the administrative proceeding. If you neglect to give the advisory and the person refuses, then the refusal will not be admissible in the administrative proceeding. The officer, so 39-2014, the officer shall inform the individual that North Dakota law requires the individual to take the screening test to determine whether the individual is under the influence of alcohol, and that refusal of the individual to submit to a screening test may result in a revocation for at least 180 days and up to 3 years of that individual's driving privileges. Very fancy speak there. So we basically have the recommendation that went out on the memo is that you would still use that the test I'm asking you to take. You have to make sure that you're talking about the screening test. Screening tests right now are only good for alcohol, so you don't have to say alcohol or drugs. And then we switched it around, so you're saying you're advising that their individual driving privileges may be revoked for 180 days and up to 3 years. So it's going to be more consistent with the last slide I showed you, okay? But you do have to include those words, screening test I'm requesting, okay? So back to your question about the getting a warrant. So the problem is, technically, no. In theory, if you have read that implied consent advisory under 39-2008-3A and they consent, you're good, okay? And you should not need to get a warrant. You should not need to give them this additional advisory. You should be able to get your test, and it should be admissible.
Or either blood, breath, or urine.
Blood, breath, or urine. Okay, that is what is supposed to happen. So the problem, of course, is if they do refuse. Okay, so this is where we're basically advising an additional advisory. Okay, so to comply with 390801F, 1F, okay, we are recommending that if someone refuses a breath test, okay, you've read them implied consent, you say, will you take my intoxilizer test? And they're like, no, go pound sand. We're recommending that you say, I should also inform you that refusal to take this chemical test I'm requesting is a crime under North Dakota law. Are you sure you don't want to take my test? And if they say no, now you can hook them up for the refusal, and we're going to have no issues on the criminal side because they were advised, right? Consistent with the Constitution, mind you, okay? So no magic language. This is just an example, okay, of what you could say. You could say, you know, by the way, if you don't take this, I can charge you with another criminal offense of refusing. I mean, there's any way you can say it to share the information that if they don't take your test, they can have additional charge, okay? But we thought you probably would prefer kind of having a script and knowing what you should say, so we came up with this, which is similar to what you've been saying, okay? So on the blood and urine side, again, if they refuse, if you've read that implied consent advisory on the administrative side, and they say, you say, will you take my blood test, will you take my urine test, and they say, no, I'm not going to, then you still have to go get a warrant, okay? Because you cannot charge them with refusal on threat of a criminal charge, right? So in that case, you would still have to go get your warrant. Once you have your warrant, you would come back and say, look, I have a warrant, and so I'm going to inform you that if you don't take my test, it's a crime under North Dakota law. Do you want to take my blood test? Do you want to take my urine test? Okay, and if they say no, then you can hook them up for refusal. If they take it, then great, we have a sample that we can test, okay? So it is still a very similar process to what you've been doing. What is better here is that there's no magic language. It's just making sure you guys need to get something that you're comfortable with so that when you go into court, you can say, I advise them of this, and you know exactly what you said, and you say it the same every time so that you're comfortable with the court process, and we can meet that requirement, right, that they were notified of the consequences of refusal consistent with the Constitution. So that would only be required on the blood and urine, though, after you get the warrant, okay? So we can't refuse them without the warrant, but if they consent, we're good to go. So the problem that has come up, or the issue that has come up, the question that we keep dealing with is the situation where you already know you're in a jurisdiction that you have to get a warrant for a blood test, okay? So I think a lot of officers are just right away starting that process before they've even maybe technically completed their PC investigation, and they're having, you know, another officer want you to go start this or whatever. Which is fine, right? The quicker we can get this stuff processed, the better. So in that case, you technically could, if you have that warrant, you could read it all at once. I mean, you could still do, you know, the advisory and then say, and by the way, it's, you know, I have a warrant, so it's a refusal if you don't do it. You know, you can do it all at once if you want. We just are hoping that we can still get consent sometimes and not have to go through that warrant process. So especially those of you who are in jurisdictions that you have, you know, medical facilities that are working with you and cooperating with you, and you don't need that darn warrant, you know, then you wouldn't need to threaten the refusal, because it's not going to be necessary. Okay? Yeah.
The person that has fallen down drunk, as a prosecutor, would you have a problem with agencies who would say, well, just forget the warrant, I already have proof that there's under the influence of alcohol, I don't need proof of subdivision E, I believe, of the refusal portion?
I mean, that's always going to be situational, right? But no, I would be prepared to go to court on an under the influence if there was enough physical evidence to support that. So if you have the falling down drunk and you have the video and you have, then yeah, I probably would be comfortable going to trial on that as an under the influence case. Not every prosecutor is, you know, so some prosecutors, if they don't have that test or don't have that refusal, they're much more hesitant to, you know, try to go pursue that case. So that's, you know, I don't know if that answers your question, because it is going to depend on, but you're right, you don't always, I mean, you can read implied consent and ask them to take the test and they say no, you can technically be done with your investigation. You don't have to secure the warrant. You don't have to ask them again to refuse. You don't need that additional refusal charge. But I do think you'll run into some prosecutors who that will be the excuse they need, right, not to pursue your case. So that would be the issue there.
With that being stated, though, you still have the ability to submit the report and notice for the refusal. You're just not going for the criminality of the DUI. So you still got them on the hook for the administrative process.
Correct.
And it's going to fall back to what we used to do in the old days when they refused.
Correct.
You just did the report and notice and you took your lumps after that. So you're not
Correct.
handcuffed by the aspect that if you don't give the warrant for the blood on the refusal, you still can do the implied consent thing.
Correct. Yeah, and you're right, that is how we used to do it before we had, right, the criminal refusal charge. If they refuse, we'd hook them up on the administrative side, get the revocation, and then, you know, most likely, probably, 90% of the time they got amended down to refusal, or reckless, excuse me, but if you have that, you know, and we have videos now, we didn't have good video evidence either, you know, 8 years ago when we were doing that. So perhaps, you know, if you have good physical evidence, we'll have prosecutors who are more willing to pursue those under the influence cases, even if you don't have the refusal. So, yeah.
And I was just wondering if you ask for a blood test and they refuse, you switch then and say, how about, would you be willing to do a breath instead? And then they refuse the breath as well. What are your thoughts on calling it good from there?
I'm trying to think that through. So you read them implied consent and say, will you take a blood? And they say no. And then you say, well, will you take a breath? And they say no. I guess I don't see a problem with that. It says the tests or tests I'm requesting, right? So no, I don't think I see a problem with that.
So then when they refuse the breath, then we could read that actually
Right.
for me,
Right.
and then we could be done with it.
Right. I mean, you can anticipate defense attorney's going to go nuts on you, right? And why didn't you just want to have to get a warrant? You're just trying to subvert the law, aren't you? No. You know, they're going to go after you, but I don't know why you couldn't do that. I mean, you can ask for any test if you want to, you know, right? It's your choice what test you ask. So, but you very often will have people say to you, I don't want to take a breath test, but I'll take a blood test. And you'll be like, fine, then let's go take a blood test, right? I mean, you can do that. So I don't see why this would really be any different, and say, okay, well, you don't want to do a blood, you know, would you be willing to do a breath for me instead? It's like giving them an option, right? Play it off as, I'm trying to be helpful. I'm just trying to give you options, you know, what
That's
works
the way
best
I'm
for you.
looking at it. Give them the option, and it also saves
Yeah.
us time and kind of
Yeah.
builds you to the
Yeah.
warrant.
Yep. No, I think that's correct. Yeah.
Just so we have clarification with you, again, it was my understanding previously we could use, PBT results in, criminal cases.
Correct.
But then reading the few slides back, it says that it should be admissible in any criminal case. So we're now good to go using.
If there's a probable cause challenge, and if the slide doesn't say that, it should. So if there's a probable cause challenge, and they're claiming you didn't have probable cause to arrest, the PBT is admissible in that hearing, in that motion hearing.
Okay, just for probable cause.
Correct.
Okay.
Correct. Yeah. Yeah, so the PBT is not supposed to be, yeah. I mean, and the court's gotten pretty sticky about that too. They're getting pretty particular. There was a case recently where they played a video. And in the video, the defendant makes some kind of comment about their 0.8, their 0.8 or something. And the defense didn't really object and nothing happened. And the Supreme Court said, nope, we don't really know how the jury, because the jury asked a question. I think that's what happened. The jury asked a question about that. And so the Supreme Court said, hey, there was reference to a PBT and there shouldn't have been. So even though there really hadn't been an objection or an actual like number that was correct or accurate or anything. The Supreme Court still said reference to it was a problem. So it's really important that we not bring those up in trial. What is still not clear to us is we have the law that says if they refuse both the PBT and the chemical evidentiary test, then the refusal of the PBT is supposed to be admissible. But we have had some district courts, judges still say they're not going to allow it. So that hasn't gone up yet to the Supreme Court, I don't believe. I'm not aware of any cases that have addressed that. But we still have a question there about whether the refusal of the PBT is admissible in trial in that circumstance. So that's something we're still not entirely clear on, that we're still testing, okay? So questions about this process, question about the language. So again, we were just, again, we had some different opinions about whether we should even tell you what to say because there is no magic language, and that was supposed to be the beauty of the statute. But we also didn't want you to send you out there not knowing what you were supposed to do or what the expectation was, okay? So the idea was, this is kind of an example of the sort of statement you should make if they refuse, to give them that warning on the criminal side, right? That they could face a criminal charge. But how you do that is really up to you, okay? How you say that. Okay, so no specific language is required to advise of the criminal consequences of refusal. There is no statutory language, okay, that is required. The statute does require that you advise subjects of the consequences of refusing a chemical test consistent with the Constitution, or the refusal is not admissible in a criminal proceeding, okay? So that's where they get us on the criminal side. If you haven't somehow informed them that there are criminal consequences to refusing, then that refusal is not going to be admissible on the criminal side. Now, as I said, that is the provision where I see the most litigation coming out of, because I am pretty sure what the defense bar is going to try to do is still tie that to the administrative side. I think they're going to try to require that it has to be both of them. And so I think they're going to try to make an issue out of that. And we very specifically were trying to separate those. So I'm afraid that they're going to try to say that administrative advisory is still required on the criminal side, and it's really not supposed to be. Now, in most circumstances, you will have read it, okay, because that's what we're going to do on the administrative side. So most of the time, that's not going to be an issue. But again, in those cases where you don't read it or can't read it for some reason, that's where we foresee a challenge. Again, I already talked about the fact that, the beauty of this is that the Constitution doesn't require an advisory. So when you're analyzing this particular provision, consistent with the Constitution, it means nothing, really means nothing. So that's where, again, we think we'll have some wiggle room with what you say and how you say it, because it's not even really required, okay? And we're only doing it and recommending it because that's what the legislature thought they were doing. And so we want to play ball with that because we don't want the legislature to come back in 2 years and do something, crazy again. So we're just trying to, meet the intent of what they were trying to do, okay? So again, the legislative intent was to make sure that persons knew the consequences of refusing, but there was no magic language that was going to be required. And this does not impact chemical test results, which will still be admissible whether an advisory is given or not. So that is the real beauty here, is that if you just choose to not read implied consent at all and they consent to a test, that test will be admissible, okay? So we're in good shape on that side. So where we need to be careful is on those refusals now, which is kind of the opposite of where we've been, right? I mean, for the last year, the refusals have been the sweet spot because the advisory doesn't do anything to a refusal. So we are kind of switching gears here, and now we have to be more careful and cognizant of what we're doing on the refusal side, because that's where we could lose evidence. And it's really hard to go into court and have you say, I did my field sobriety testing, and I talked to them, and they were, they appeared drunk and they smelled drunk, and I arrest them for DUI. And we're done. Okay, because we can't talk about the fact that you asked for a test to prove they were impaired and they wouldn't take it. I mean, like, the case is going to be done at that point, which is odd, right? And a jury's going to be like, what the heck happened? Why did this officer not go do something? Why are we not hearing anything else? So it's going to be pretty critical on those refusal side that we, give them the advisory language that they're looking for, so we know we've covered our bases, okay? And can get those refusals in. This also has come up. One of the questions was, Miranda. So my advice always is to arrest, read Miranda, read implied consent, do the test. And the reason for that is, some people do Miranda right away, and that's fine, but if you're one of those that does not, I do think Miranda should be read before the implied consent advisory, because the words of refusal will be suppressed if they have not been Mirandized. So if they've been arrested, they're technically in custody at this point, right? It's no longer an investigatory detention. They're in custody because they've been arrested. And if you say, right, here's your implied consent advisory, will you take my test? And they say, why would I take your test? I'm so freaking drunk. Okay, you want that evidence, right? But if you haven't Mirandized them, that evidence, that statement can be suppressed. Okay, so you want to make sure that you're still Mirandizing before you ask them, after they're arrested, and before you ask them if they'll take their test, because any of those words that they say at that point, we want to make sure that they're admissible. Okay, so that's the recommendation on that.
So now that we've reviewed what House Bill 1534 changed, I want to break down exactly what we are recommending regarding the DUI process and the implied consent advisories. So starting out with the preliminary breath test, there's been a lot of questions about the requirements for the PBT. Nothing changed with regard to the PBT. The law stayed the same, and that statute wasn't amended in any way that would impact the advisory. The change we are recommending is that we are suggesting that you read that advisory word for word as it's written in the statute. Specifically, we're advising you to state that the officer shall inform the individual that North Dakota law requires the individual to take the screening test to determine whether the individual is under the influence of alcohol, and that refusal of the individual to submit to a screening test may result in a revocation for at least 180 days and up to 3 years of that individual's driving privileges. So that has not changed, but we are, as stated, recommending that you go back to that specific statutory language. This is very similar to the implied consent advisory for the evidentiary test. You'll see a couple differences, that it only refers to alcohol because we don't have a PBT system for drugs at this time. Again, we're hoping that in a couple years that might be an option, but right now the PBT is only available to detect alcohol. And then it refers specifically to the screening test, and it talks about revocation for at least 180 days, whereas the other advisory says a minimum of 180 days. Otherwise, these advisories are very similar. The report notice forms will be modified to reflect this change as well for the statutory language. Same kind of rules would apply, that if you're asking for that screening test, you would just explain, I'm the officer asking if you'll take my screening test. Are you willing to take that test? Just to make it clear that you're asking as a law enforcement officer that they take that screening test. There have also been a lot of questions about whether this advisory is separate and different from the evidentiary test, and the answer to that is yes. You do have to read a separate advisory for the screening test, and then read the second advisory for the evidentiary test. You cannot refer to the other screening test and say, hey, I read you that advisory. You do have to provide an advisory for the PBT, and then a separate advisory when you're asking for the intoxilyzer test. It also has come up that you do have the ability, if it's a PBT, to ask someone, you'd read the advisory, and if the person refuses that advisory, you can be done with your investigation at that point. If you have not established probable cause to arrest, you could take the option of filling out the report notice form for the refusal of the PBT and not arresting them for DUI. This should be a very rare instance that would happen. Most of the time, you're going to have probable cause to arrest and you should move forward with your investigation. But if you do have those circumstances where you just don't feel that you have enough to arrest, the subject is not cooperative, but you have formulated the opinion that their body contains alcohol, you've read this advisory and you've asked them to take a PBT and they refuse, you could proceed by just issuing them a report and notice for the PBT refusal and being done. Most of the time, however, whether they take that PBT or not, you are going to move forward with your investigation. So once you have established probable cause to arrest, this is a good time to provide Miranda warnings, if you haven't already done so. Some officers make a point of reading Miranda right away, or the minute they put them in the squad car, they're providing Miranda. And that's fine if that's your normal practice. But for those of you who don't typically read Miranda or try to avoid having to read Miranda, it is recommended that you, after you have placed someone under arrest for the DUI, that you would at that time read Miranda before reading the implied consent advisory and asking them to take a test. The reason for that is that the North Dakota Supreme Court has determined that the words of refusal can be suppressed if they have not been Mirandized. Obviously, at the point that you've placed them under arrest, they are in custody. It's no longer an investigation. They are in custody. And if you ask them questions at that point, it is deemed to be an interrogation. If it is a custodial interrogation, then Miranda must apply. So this is important if you have a subject who makes comments such as, "I'm so drunk, I'm not going to take your test," or we both know I'm drunk, I'm not taking your test. We want those words, those admissions, to be admissible. And if you have not provided Miranda, then those words of refusal may be suppressed. The action or the act of refusing or the decision not to take the test would still be admissible, so the case would not be over by any means. But if we do have those types of admissions, we would want the admissions to be admissible. So once you've placed them under arrest, read Miranda, then we would recommend you read the new implied consent advisory, and we'll repeat this again just to make the point that we are recommending that you read what is in the statute. The law enforcement officer shall inform the individual. North Dakota law requires the individual to take a chemical test to determine whether the individual is under the influence of alcohol or drugs, and refusal of the individual to submit to a test directed by the law enforcement officer may result in a revocation of the individual's driving privileges for a minimum of 180 days and up to 3 years. And you would conclude by saying, "I am a law enforcement officer. I'm asking you to take this chemical test, whether it's blood, breath, or urine. Will you take my test?" If the individual consents at that point and says they'll take your test, whether blood, breath, or urine, no further advisory is going to be needed. We have consent. Consent is an exception to the warrant requirement. That test will be admissible. The only issue may be the jurisdiction that you're in. We do have the fact that a lot of our medical facilities are not willing to do a blood test without the warrant. So that issue is separate from the implied consent issue. So even if someone consents after you've read this advisory, if they consent, you could run into the fact that you still need to go get a warrant because the hospital itself is going to require it. The other question that has come up is whether an individual would even need to read the advisory. And I think the technical answer to that is no. We would have the ability under this new statutory scheme to just ask someone to take a blood, breath, or urine test, and if they consent, that test should be admissible. The problem, of course, is if they refuse at that point, in order to proceed administratively and potentially criminally, we would need to read some type of advisory. So again, I've been asked at that point, if they refuse, can you then read the implied consent advisory? And I think the answer to that is yes. So that is not, at this point, not the preferred way of proceeding. It's not the way we would recommend. We would rather have officers just kind of follow the process. The statute does say, of course, that officers shall read this advisory, so we don't want to advise that you intentionally don't comply with the statute. We want you to comply. But again, depending on the circumstances that you're dealing with, or if you just forget for some reason, consent is consent, and the test should still come in. Also, under the new exclusionary rule, the only thing that would be excluded is if they refuse. So if you get a test, there's no harm, no foul.
So once probable cause to arrest is established, place the individual under arrest. And that's a good time to read Miranda, as I was just saying, if you have not done so already, to ensure that those words of refusal are going to be admissible at trial. So some of you, Mirandize them the minute you put them in your back seat, that's fine. But if you do not do that, make sure you do before you ask them to take a test. So do Miranda, then read the new implied consent advisory. The same advisory, again, should be used whether you're asking for a blood, breath, or urine. It's the same advisory. Exact language is being recommended. So that language again, I must inform you that North Dakota law requires you to take a chemical test to determine whether you are under the influence of alcohol or drugs, and refusal to submit to a test may result in a revocation of your driving privileges for a minimum of 180 days and up to 3 years. If the individual consents, no additional advisory is needed. Depending on the jurisdiction, you may still need a warrant to secure blood evidence. Okay. So if the individual does not consent, the following procedure is recommended. For breath, provide the following advisory. I should also inform you that refusal to take the chemical test I'm requesting is a crime under North Dakota law. We don't think it's necessary to say chemical breath test or anything like that. It's just refusal to take the test I'm requesting is a crime under North Dakota law. Okay, so you can say the same thing again for all three tests. The language can be the same. It's just the stage that you're going to read that advisory. Okay, blood, urine. Again, if they have not consented, then you need to go get your search warrant if you haven't already done so, and then provide the following advisory. I should also inform you that refusal to take the chemical test I'm requesting is a crime under North Dakota law. Okay, so you don't have to refer to the specific test you're requesting. No specific language is required for this one. We just think you should say something.
So here is the new report and notice form. You'll see at the top that it has been labeled as version 9-2019. If you have the 8-2019 form, that one is going to be rejected by the DOT. So it's very important that you make sure any old forms are thrown away. So check squads, check people's notebooks and the documents you're keeping by your intoxilizer, and make sure all of those old forms are being thrown away. You do need to use the 9-2019 form. The DOT is very strict about this, so if they get the old form, the old report notice form, they're going to toss it. They just will not even accept that report notice form, and there will be no administrative proceeding in that particular case. So it is important that you make sure you're using that new form, 9-2019. The tracks form should also have been updated. Those are actually updated quicker than we get the paper copy sent out. So those of you using tracks, that should all be up to date. So you should be safe if you're using those. They actually did make some other changes to this latest version, the 9-2019 version, which we will go through. But because of those changes, they're going to be even more strict about making sure you use the correct form. And it's this 9-2019 form that also has the current implied consent advisories for both the screening test and the evidentiary test as written in the statute. So you can be using those forms to provide those implied consent advisories to drivers when you are requesting testing. So you can see where we've circled there up at the top, one of the changes that they made to the form was that they got rid of the AM and PM box. This was actually at the request of law enforcement who prefer to use military time. This appeared to be a problem for the DOT when officers were putting in military time. They weren't quite sure what to do with it. So just to simplify matters, they took out those AM, PM boxes. You can use military time. You're encouraged to use military time. If you do not use military time, you probably should write in AM, PM because we need to be able to determine if something happened at 2 a.m. or 2 in the afternoon. So just whatever system you use, make sure you're consistent throughout the report and notice form. The timing is critical because we have to show that testing occurred within 2 hours of the time of driving. So additionally, these boxes with the date, the time of driving, and time of arrest very often are left blank. And I know exactly what happens. You're going to call into dispatch and verify the time and then forget to do it and go back and fill it in. But this is critical. If that information is not provided on the report notice form submitted to the DOT, that report notice form will be tossed. The DOT will not consider it, and there will be no administrative license, suspension, or revocation. Again, the time of driving is critical because we have to establish that the person was tested within 2 hours of the time of driving. It's also critical that the date is on there because these forms need to be issued immediately and they need to be mailed to the Department of Transportation within 5 days of issuance. So if you haven't filled in the date and time that things are occurring, the DOT does not have jurisdiction and no action can be taken. So very important that that information is provided. The DOT added an entirely new section or new box to the report and notice form regarding the screening test. And it's my understanding that these changes or this addition was made at the request of the hearing officers. On the old form, they were not always able to determine whether whether a PBT test had been given or if they refused or had it even been offered. So they asked to have this box added so that it was more readily clear to them whether the PBT was an issue at the administrative hearing. So there have been a lot of questions about this box, and the point of it is that this is only in reference to the PBT. So when you're filling out this particular section, it is only in reference to the PBT. So the question about whether you have formulated the opinion that the person's body contains alcohol, that is very specific to the PBT. And one of the issues, if there is a PBT refusal, is in order for us to have that refusal, one of the issues that has to be determined is whether the officer formulated the opinion the person's body contains alcohol. So this just provides that prima facie proof that you did formulate that opinion. Rather than trying to decipher that down at the bottom with your reasonable cause and your probable cause statements, this is making it very clear on its face that you did formulate that opinion, which is why you requested the PBT. There's also 2 other boxes there that talk about whether the person refused the screening test or whether it was administered in accordance with the approved method. I've had some officers say to me that they, or question whether they should fill in both boxes because even if someone refused, that doesn't mean that they didn't administer it in accordance with the approved method. I do not believe that was the intent of this section. I believe what those boxes are trying to establish is whether they took the test or whether they refused the test. So if they refuse the test, obviously you mark the first box, but if they took the test, you would say the screening test was administered in accordance with the approved method. I understand that there has been already a new handbook sent out with the new report notice forms that does address this in more detail. So if you have additional questions, you might want to refer to that handbook to answer those questions. But I think the important thing is to recognize that when filling out this box, it is specific to the PBT. It's not really in reference to any other portion of your investigation or the evidentiary test. So you will see on this section of the report notice form that again the DOT did remove the AM and PM boxes. So as indicated earlier with the report notice form, this change was made at the request of law enforcement. So you are free now to use military time without there being any issues with that. If you aren't using military time, then you just need to make sure that you're adding AM or PM. I don't think that the DOT is going to care which one you use as long as you're consistent throughout the document and they're able to establish that the test was administered within 2 hours of the time of driving. I also wanted to point out that refusal box at the top. If you refuse, you're supposed to go across, not down. So sometimes people mark refusal and then mark underneath blood, breath, or urine. But if they refuse, you should be going down. It's vertical and mark the blood, breath, urine at the end of that sentence to indicate which test they refused. Obviously, if they take a test, you want to make sure you indicate what test they gave you, whether blood, breath, or urine, and then the time that the test was obtained and the test results. This is something else that is very often left blank. You get everything ready and then forget to go back in and fill in those test results, or in those situations where you have a blood test or a urine test and you're waiting for those, when those come back in, you forget to go back into the report notice and fill those in. Obviously, that information is critical. If the report notice form does not provide us with the test results or the time of the test, the report notice is going to be rejected and there will be no administrative hearing. I can also tell you that if your test is below a 0.08, or it's outside the 2 hours, so if you just know that you didn't get your test within the 2 hours, then there really is no need to send in the report notice form. If we can't establish the test was given within 2 hours of the time of driving, or if we can't establish that they were a 0.08 or greater, then there will be no administrative hearing suspension, and we'll have to rely on the criminal side to get the conviction, which should lead to a license suspension. I always say send it in anyway, who cares? We can keep track of, it helps for statistics and it just keeps you in the practice of doing that. In case you miscalculate the time or whatever, then there's just no issues. The DOT would disagree with me on that. They'd prefer not to get them. If they're not going to process them, they don't want to be bothered with them. But I am letting you know that, if it is below that 0.08 or it's outside the 2 hours, that those report notice forms will be rejected, for lack of a better word, and there will be no action taken on that report and notice form.
Sorry, this one got a little distorted. They did add a new box. So this, I believe, is new. The screening test was administered in accordance with the approved method. So if you are doing a screening test or a PBT, make sure, you have officer formulated an opinion the individual's body contains alcohol, they are advised of the implied consent advisory, and they either refused or it was administered. Okay? And I think that's to help the hearing officers. I think that was a request they had, because sometimes they weren't able to tell, like you would mark the box that you had read it, but then there was no box that they had refused it or taken it, and so they weren't always clear whether they were dealing with a refusal case or not. So that was supposed to help them, I think, more than anything. All right, so new box to be aware of. Okay, so the other issue here is making sure that you fill in the test results when you get them. So this is another very common mistake, is that officers, get the report notice already, and then when they're done with that breath test or that blood test comes in later, they forget to fill that information in. So you need to make sure that you're marking which box, whether it was a refusal or a test, and then make sure you indicate the time obtained over here and the test results, okay? I'm not seeing too much of this, but you don't need to include the words by weight. That issue's been resolved. The Supreme Court said it's not necessary, so you don't have to write in by weight. But you do need to have those tests, and that's again where that AM and PM becomes important, so we can make sure that that test was given within 2 hours. If the time obtained is outside of the 2 hours of the time of driving or the time of crash, tossed, okay? So on the administrative side, we can only suspend if a test was given within 2 hours. Okay, there's no under the influence, suspension. Okay, you can only suspend on the per se, so that test has to be within the 2 hours. So make sure you're paying attention to the clock on those. Technically, if you know it's outside the 2 hours, you don't even need to send it in, okay, because they won't do anything with it. I always recommend that you send it in anyway, but because I just think, why not, right? And you're sending in other stuff, and you don't want to get in the habit of not sending in the wrong ones. I just see problems with that, but the DOT doesn't like getting the ones that they're going to reject. But I'm less concerned about that. So I say just send them in. I don't care, but they're going to toss them. So if you know that you have that kind of thing where it's below a 0.08, they're going to toss it if it's below a 0.08, or it's outside the 2 hours, we're done, okay? Nothing's going to happen with it. Temporary operator's permit. Okay, this is a really skinny line. It's a very skinny line that's in between these two boxes, but it's a super critical, okay? Super critical line. You have to mark whether you issued or mailed the temporary permit and the date, okay? Now remember that if it is a breath or a refusal, you have to issue it immediately, okay? The only time you can mail it is if it's a blood or a urine and you're waiting for those test results. So we get a lot of refusal cases that are mailed later. I don't know why that is, but if it's a refusal, you need to issue it right away, okay? Before you walk out of the correctional center or whatever, you need to make sure you give them, you've issued it and you've dated it, okay? If you forget to date it, we don't know when the permit was issued, we can't know it was issued within, whatever time, and then we don't know when to have a hearing. So that date is critical in order to meet the statutory timeframes. So here, as I just said, again, make sure that you're filling in that date, okay? That date is critical. And then don't forget to sign it. So this is another area where officers very often forget to sign it. On the tracks side, you can do that electronic signature, but if you're using the hard copy, you need to make sure you write your name and you sign your name. And if you don't, it gets tossed, okay? So those are critical requirements. The reasonable suspicion, probable cause, again, this is required. So if these are not filled out, if there is not something written in here, they're gonna toss it. So every once in a while, we'll get ones that are just blank, that the officer just forgot to fill these out, and those get rejected. So there has to be something on the face of the document so that the department can say that you had reasonable suspicion to stop and probable cause to arrest. Okay, so you have to fill this out. Okay, if you don't, it'll be rejected.
How important is the probable cause portion of that? I know several years ago they demanded significant, bloodshot eyes, odor on breath, failed tests, stuff like that. How important has it changed between then and now?
Not really. There has been no new case law on that issue. So that is kind of where we're still at. But I think they changed these boxes a little bit too since then. So, technically, if you're saying failed sobriety test and there was an odor, that is probable cause. So I think you should at least get a hearing, okay? And then you can explain more at the hearing. But I still would always recommend, you hate to have something tossed for that reason, so I would always recommend that you just say 6 of 6 HGN, 2 of 8 on whatever, so there's something, right? I mean, it doesn't have to be everything, but something, okay? Same over here. I mean, I've seen ones where they just say, traffic violation, and that's sufficient. I mean, they go through. I'm sorry, crash. Crash goes through. Typically with traffic, they'll say speeding or something, or already stopped. They'll say, community caretaking, or, they'll explain it a little bit. But it doesn't need to be a lot. It doesn't need to be lengthy. It just needs to be enough so that we understand what you were doing. Okay? Just putting already stopped doesn't tell me much. Why were you talking to them? Why did you approach them? Why did you, it still leaves a lot open for interpretation. So that's where you want to say, already stopped community caretaking, already stopped roadside assistance, whatever. They approached me, whatever the situation is. And then down here again, you have to sign and date a second time, so don't forget that down at the bottom as well. Signature, name, date, okay? So all of those things need to be on there. Failure to do any of those is going to result in it being rejected. So as you know, there are 3 copies to the report and notice. And do you guys get drafts of those? Did everyone get a copy of the report and notice? I saw one of them here, yeah. So we have the 3 versions, the driver's license version, the law enforcement version, and the driver copy. Every once in a while, the driver copy is the one that gets mailed in to the department. Never the law enforcement copy, which is interesting. It's usually always, if there's a mistake, it's the driver copy that was sent in. The problem with that, if you look at the form, you'll see this, but the driver copy doesn't have the probable cause and the reasonable suspicion boxes. So when the department gets that, they can't know. They don't have a prima facie showing of why you stopped them or why you arrested them, and so they have to reject it. Okay, so it's important to make sure that you're sending the right copy into the department so that they can take action on it. So there's that one report for the DOT, one report for you, and one report for the driver. Driver's copy does have that notice to driver. So here, this just came up with me. I just had a DUS case where the kid it was a minor 0 tolerance. So he was issued a report notice for MZT, and then just given a minor in consumption. Okay, went to court, pled guilty to his minor, got his deferred, right? And the court doesn't ever explain anything about their driver's license. The court probably doesn't even know, okay, that there's this report notice and MZT suspension. So the kid, 28 days later is driving, suspended license, okay? So he fights it. And we have an issue. They want a notice requirement. They're challenging notice, okay? So I had a couple problems here because we don't keep the driver copy anywhere, right? You give the driver's copy to the driver. There is no other record of the driver copy. So I had no proof that the kid had actually been advised, okay? And this is why this is critical, because it says the notice to driver, unless you make a timely hearing this request, this notice is the director's order suspending or revoking your driving privileges. This is the order. This is the order. They do not get anything else. They are never mailed anything. So when you issue this report and notice, that is that. That is the notice they get, that if they don't request a hearing, they lose their license in 25 days. Okay? So this is really important that they get this notice. And then this hearing request talks about you can have a request. The hearing must be done you must request it within 10 days of the issuance of the temporary permit. So this is why it's so important that you date the permit, because they have 10 days from that date to request the hearing. If you don't date it, that permit, we don't know what was issued, okay? And that permit is good in perpetuity because we don't know when it was issued and we don't know when they would request a hearing. So this is really critical because this is the only notice that anybody who gets a DUI or an MZT will ever get that their license is going to be suspended, okay? And so when I was explaining that to my officers, they were surprised. They're like, well, but don't they mail them something when they're actually suspended? I'm like, nope, this is it. This is the order, okay? This is what tells them they're suspended. So really important, number one, that you know that, that you understand that, because if you ever are faced with a DUS case, you need to be able to explain what that report and notice is doing, right? But number two, that's why it's so critical that they get that copy, because that's the copy that tells them they're losing their license and they have that due process right to a hearing. And if we can't establish that in court, they don't get a DUS, okay? Because we have to prove that they had notice and a right to hearing. And if we can't prove that, then they get away with their suspension, okay? So those are really critical pieces on your side when you're issuing those report and notice forms, okay? It's a whole other issue that I don't have a copy when I go to court, okay? We're gonna have to deal with that one later. But I understand on the Trax version, you can go back in on a Trax version and pull an old report and notice, is that correct? So a little bit better luck on a Trax report and notice than the hard copies, but anyway, that's part of the reason I wanted to bring that up, because this is their only notice of the order suspending or revoking the driver privileges, okay?
So here are the new implied consent advisories that are available on Form 9-2019 and the Trax version of the report and notice form. As you can see, these are straight out of the statute. So they are the statutory requirements for the implied consent advisory for both the screening test and the chemical test. There was one typo still in the form I got, so I crossed that off, but that was a minor issue, and the new form should be updated. But those advisories are right out of the statute, and if you're reading off the report and notice form, those advisories should be adequate. Again, our advice is, after reading that advisory, to say something along the lines of, I'm a law enforcement officer, I'm asking you to take this blood test or breath test or urine test, and asking them if they'll take the test. We did not want to put that specific language on the report notice form, because we did not want to imply that that was part of the implied consent requirements. So that's more just to answer those questions or those concerns we have about the fact that the implied consent seems impersonal and seems third person, to just make it clear that you are the law enforcement officer who's asking the individual, the driver that you're talking to take that chemical test.
All right, so we have just, whenever I go and do these presentations, it's always very interesting to hear what you all have to say and the issues that you have with the administrative process. And so one of the goals we have is we want to try to demystify, some of that, some of the myths that are out there, try to explain the process a little bit and answer those questions that you might have. So we do have a bunch of commonly asked questions that I wanted to kind of address through this presentation. And then at the end, if you have additional questions, now would be a great time to talk about them. But the most common question that we get is, why are defense attorneys allowed to ask questions beyond those 3 or 4 issues that are supposed to be addressed in administrative hearings? So we know that hearings are about, did you have reasonable grounds, right, to stop, to believe they were DUI or APC? Did you have probable cause to arrest? Did you give them a test? What was the result, or did they refuse, right? And it seems like defense attorneys are able to go well beyond that. They're mini trials, essentially, right? And so there's some frustration about that. And what you need to know is that the Supreme Court has essentially interpreted the statute to allow defense attorneys to inquire into any issue that may impact those issues to be proven at the hearing. So when we're talking about the basis for your stop, like, why are we talking about that? That's not one of the issues. But it is it's a due process concern that adds to whether or not you had the right to investigate them, whether or not you had the right to make the stop. And so they've said, yes, we're going to allow them to inquire into the stop to make sure that there was due process and that you didn't violate the Constitution when you made that traffic stop. So that's an example. So this includes whether the stop was based on reasonable suspicion, whether the FSTs were administered correctly, and whether they should be considered in establishing probable cause, and then whether the chemical tests were administered in accordance with the approved method, right? So those are all things that you get grilled on and get questioned about, and that's because we need to make sure that that evidence was obtained accurately. This is a due process hearing, okay? I mean, the purpose of the hearing is you can't take someone's license without due process. And due process means that their constitutional rights have not been violated, and that you've complied with the statutes, okay? So that's why they're allowed to get into those things. So anything that touches on those 4 issues to be addressed is fair game at these hearings. Additional issues that might be explored include whether a driver was afforded their limited statutory right to counsel or whether they were denied an independent test. So these are things, right? We know that it's not one of the 4 questions, but we also know that if you did not let them talk to an attorney, that's going to be an issue at that hearing. And we're going to have to address why, because they have a due process right under our statutes to contact an attorney. Excuse me? Or attempt to, correct, yep. Given a reasonable opportunity to consult with counsel, okay? So that's why. I mean, that's why these hearings seem to be broader than the scope that you think they should be. And it's primarily because the Supreme Court has said all of these issues are relevant. These are all due process issues and considerations to consider when determining whether to take someone's license from them. And so that's why. The unfortunate thing is, you know, most of you don't have a prosecutor there with you, and so you can't object on your own behalf. And you know, sometimes I hear stories about the scope going beyond getting personal. Even I've heard some pretty bad stories about that, and that's unfortunate. I mean, those are, in my opinion, maybe hearing officers that aren't controlling the process very well. But you know, we don't want that. Most of the time it goes pretty well. I think you would agree, most of the time they're okay, and they really do make an impact. I just had a case that the administrative hearing got dismissed because the hearing officer couldn't get it scheduled in time. One of those had nothing to do with the report notice or the officer, or we didn't even have a hearing, he just couldn't get it scheduled. And the defendant signed a Rule 43, was going to plead guilty. Before the court could approve it, he said he wanted to withdraw his guilty plea because he didn't lose his license. He really didn't want to lose his license, and he was willing to go to trial now to not lose his license. And he was allowed to withdraw his guilty plea. So that is an example of, had he lost his license, and he would have, if we'd had that administrative hearing, he would have pled guilty right away and it would have been done. And so it does matter. It does make a difference to these drivers. Losing their license is probably a bigger punishment than paying a fine for most of them. And that's the piece that they want to protect. So having these administrative hearings that happen quickly and have, you know, swift results for them really do, I think, make a bigger impact than sometimes you realize, because it does impact the entire process. So it's worthwhile, and I know that there are some frustrations out there, but you know, we do win over 90% of these. We haven't lately because of vegan, but that's a blip in the radar. But you know, we do win the majority of these. So I think the horror stories are few and far between. Okay, and the more you do these, I think if you talk to the officers that have more experience, the more you do these, the more comfortable you become with the process. You know, so sometimes it's just getting over those first couple, and then you're ready. You know, then you can deal with it. And that's part of what defense attorneys are doing too. They're testing you, you know, and so part of it is pass the test, you know, and they'll leave you alone. Can law enforcement have representation at an administrative hearing? Yes, the statute does allow a city prosecutor or a state's attorney to attend an administrative hearing. So they can act as an attorney, they can ask questions, object, present evidence, like they would as any prosecutor. So with that in mind, I know we keep talking about this at state's attorneys meetings, that we really are trying to get state's attorneys to be more engaged in wanting to be involved in these processes. their problem is they don't get paid extra to go, and so they say that they're too busy. But they also say if you really have concerns about a case, you should discuss it with them, talk to them. They might try to attend. I think we have, the Bismarck city prosecutors are starting to go more often. So I do think that if you engage with your prosecutors and talk to them and, express what you need and want, I think some of them might be more receptive than you think, and you might get some more help with those administrative hearings. You can also call me. I can kind of give limited advice to going into those. Okay, so if you are having questions or concerns, you certainly can reach out to me about, I can give what advice I can, okay, about those hearings. Why can't law enforcement object to defense attorneys' questions at administrative hearings? Because you are not attorneys. So unfortunately, if you were to object and try to, make argument, you would be engaging in the unlicensed practice of law, which you would not want to get in trouble for. So that's why you're not. You're a witness. It's the department is bringing this action. You are just a witness, okay? So I know that we feel more invested than that, but that really is the process. It's the department saying, I'm going to, we want to take your license. They're calling you as a witness to help establish the facts. And that's why you're not able to make argument or object and do those things. Why can't law enforcement appeal on adverse decision from a hearing officer? The statute states that only the person whose license or privilege to drive has been suspended, revoked, or denied has the right to appeal. So we don't lose anything, right? It's the person it's the petitioner, it's the person who's going to lose their license. They're the only ones that can appeal a decision, okay? We cannot. So if they appeal and there's an adverse decision out of the district court, so when they appeal to the district court. The district court just reviews the record, right? There's no new hearing. You're not called in to give new testimony. They just review the record and then issue a written decision. The state does have the right to appeal those decisions. Okay? So the Attorney General's office does review those, and when there are adverse decisions, they decide whether that's a case they want to appeal. So that's how some of those cases get up to the Supreme Court, is the driver appealed, the department gets an adverse decision, and then the department can appeal from there. But if we lose out of the gate, if they say no license suspension, that's the end of it, okay? There is no appeal process for the state. What is the level of proof at an administrative hearing? The standard of proof at an administrative hearing is preponderance of the evidence. These are civil hearings. They're not criminal hearings. It's not proof beyond a reasonable doubt. It is a preponderance of the evidence. So that's a pretty low standard, which, we wish worked in our favor more often than it does, right? But it is a lower standard than that proof beyond a reasonable doubt at the criminal stage. Why can't I get consent to take a chemical test without having to read the implied consent advisory? The law has changed since this question was being asked, but because we had this statute that basically said if you don't read the advisory, you can't use the test. So it was a statutory limitation on consent, okay? So even though consent is an exception to the warrant requirement, and we used to be able to do that, when the legislature added that provision in there that said if you don't read the advisory, you can't use the test, and now you can't use the refusal, that is why you can't just flat out get consent, okay? You have to read that advisory. Now we fixed a little bit, you probably can now, right? If they consent, we're good, okay? Even if you didn't read the advisory. Why can't I get consent for a blood or urine test? You can, okay? So that question was asked earlier. You can. If they consent to that test and you can get it, great. The only limitation is those medical facilities that some won't do it without a warrant. I hear some won't do it at all. Isn't Bismarck one of those, in fact, that they won't, even with a warrant, won't get involved? So those are limitations by the medical facilities that don't know what they're doing either. They don't understand. And really, this has just been a good excuse for them to say we're out of this, okay? Because they don't want to have to tie up their resources and their personnel to help us gather our evidence. So they're using this as an out. Does the implied consent advisory need to be read word for word, or can it be summarized? Again, we are recommending it be read word for word, but as long as the advisory is provided in a manner that substantially complies with the statutory requirement, that should be sufficient. So we're recommending the word for word just so we can avoid those challenges. But as long as you are giving the accurate, and like if you really just can't find a card that day, right, the big thing is to say, I have to inform you under North Dakota law, you're required to take a test, and if you don't take it, refusal to take it, you can lose your license for a minimum of 180 days and up to 3 years. I mean, that's the important information to relay with that advisory. Can any officer observe an administrative hearing? Yes. Okay, so if you have training officers, you could have them go to anybody else's administrative hearing and observe. Okay, they are public hearings, and as long as they're not testifying or being disruptive or whatever, there's no reason anybody can't be there and observe. Okay, so certainly you can go yourself if you want to get more experience, or you can send new officers so they can observe them, but no limitation on who can attend those hearings. When a driver refuses testing, why don't we seize their driver's license? This just happened to me. It was kind of ironic that this question came up because I was just at a hearing where it was a refusal and our officer had taken the driver's license, and the driver showed up with a letter from the DOT that said, the law has changed, we shouldn't have taken your license, you can have it back. And so, I'm paraphrasing of course, but so this driver shows up at his administrative hearing and produces this letter and says, why did you take my license? And the officer's like, because my department tells me to. That was his answer. And he's like, well, you weren't supposed to. And he kind of goes after him. And, so I object. I'm like, this is irrelevant to this, this debate. It doesn't matter. But I'm also like, what the heck? That doesn't seem right to me. And I get on my phone and I'm researching it. And it does still say, the statute still says, the refusal statute says, you shall take the driver's license. So I got a copy of this letter. I followed up with the DOT and I said, what's going on? Okay. Well, they didn't realize that that the refusal still had that in there. That was their error. And they didn't realize that. And so in 2017, they had done a bill to have all of those changed so that you didn't have to take licenses anymore. And their reasoning for that was because they can still be used for identification purposes. And they also said that having people get ID cards actually costs the state money because whatever they charge for those IDs isn't enough to cover the cost, which the logic there to me seems increase the cost, but their logic was return the driver's license to them. So they thought that all of the statutes had been cleaned up and the refusal one had not. Okay, so now that they know that, their goal is to clean it up in the next legislative session so that it's going to be changed to say you don't take it. So I said, in the meantime, what am I supposed to tell officers? Because the statute does say you're supposed to take it. And they agreed. So the statute says you're supposed to take it on a refusal only, but you need to be advised that they're just going to send it back. You can take what you want from that information, okay? So I am not aware of anything that is going to happen if you don't take it. I don't think there's any legal repercussions for you not taking it, despite the fact that the statute says you shall. But even if you take it and return it, the DOT is just going to send it right back to the driver, okay? So there you go. That's the answer on that one. 2021, the goal is to change it so that you won't, it'll just, all of them will say they can keep their license, okay? All right, so I also wanted to briefly plug the TSRP webpage. So if you go to NDSAA, North Dakota State's Attorney Association.org, I don't know if my computer will click to it or not, but there's a bunch of, windows at the top. The last one is the TSRP page. You can click on that. There's a username, TSRP, password TSRP. And in there is NDSAA manuals, training videos, interesting articles, memos that I've put out when law enforcement have questions. Those memos are out there. Stuff about the implied consent. This video will be on there. The old video, which we probably should take down. All of that stuff is there for you. We are currently in the process of working on a video series. We want to be doing videos to help all of you. So we're starting with kind of the basics. We're going to do some field sobriety test videos that just show those tests being administered and kind of talk through what the process is. We thought these would be good refreshers for you so that when you're even in your squad on a slow night, you can pull it up and kind of refresh your memory about, the NDSAA requirements for those field sobriety tests. So when you're testifying, you can go look at those quickly and remember what you're supposed to do and what you're supposed to say, so that you can get more and more comfortable with using those field sobriety tests. We're going to start there. From there, we're going to do some, administrative hearing videos, so you can see administrative hearings and go and watch and see what happens and how they work. Any suggestions you have, we're open to those. We also want to do some actual in the field, talking to a driver after you've made a traffic stop and how to approach a driver and, different ways to get them to give you information and things like that. So we want to keep making this website very useful, okay, to use. So I'm always interested in feedback if you have suggestions for things you'd like to see, or ways that would be easier to navigate, whatever. Give me that information and we'll do what we can, so we can make this a good resource for all of you. I think that was it. Here's my information and Erin's information, so please feel free to reach out to us. Are there questions? Anything I didn't cover that I need to cover, or just questions in general you have about the administrative process or DUI law? Do you feel ready to implement the new law, the new requirements? All right, then thank you very much, everybody. We appreciate your time.